Good evening, y'all.
Hello, how are you?
Pretty good. Just waiting for other people to log in. We got a couple minutes. We'll get started in a minute, ladies and gentlemen. Waiting on some more people to log in. All right, we'll go ahead and get it started. um, okay, it's not that many on here right now, so I just Ayana, which Ayana is this? What's on this? Collins Roberts.
Yes.
Um, Daniel Moore. You got you. Daniel Hilliard.
Here.
Got you. Lofton. Tyler Lofton. I got you. Marius Davis. Got you. And Willie Lennon. I got you. So right now there's just 6 people in here, but the show must go on. Okay, I know. Yeah, last week I was supposed to discuss I think the Daubert case, and Merrill Dow Pharmaceuticals. Did you guys get the lecture I posted? Were you able to, was it understandable? Someone? Marius, did anybody look at the lecture I posted and read the case? Or what I call posted the PDF. Did everybody get that? Yeah, okay. I see you, Tyler. Your mic's not working. All right. Okay. So there was no problem understanding it, right, Kyler? Okay. All right. So just in a nutshell, the Daubert case. So that whole section was, and that whole everything I spoke of was about admitting scientific evidence. And by scientific evidence, that doesn't just mean reports and stuff like that. That means scientific opinion. So of course, let's say if you are an expert in a certain field, it doesn't necessarily have to be science, right? It doesn't. You don't have to be a biologist. You don't have to be some type of medical doctor. Sometimes it may be a question that. So anything can be scientific if it pertains to a specified industry. Let's say they're trying to identify a body, or they're trying to talk about how they identified the body, or how they figured out that the hair was the same hair that was bought at a salon, or that was put in at a salon. They may get a hairdresser to talk. I mean, because that hairdresser has an expertise at identifying the types of hair that a person can buy for weave. They may be asked to testify about why they deduced that this was the same hair based upon their level of knowledge. That was the dye we use, and that's how I did her hair. So, um, you know, that can be scientific. So, the Daubert case, it started out with the old case called the Fry case. The Fry case pretty much said that if it's not something that's scientific or accepted by the scientific community, is not considered science, and therefore it's not allowed in a trial. Um, the Daubert case opened it up and said, well, anything as long as it's relevant to the case, any expert testimony, any testimony from a specialist in a relevant field, um, I mean, it should be allowed. In other words, and it is allowed. So it let more in. So that means now a person doesn't have to have a white lab coat on or be a scientific specialist. They can just be someone that has expertise in what we're talking about, the issue at hand in court. So it may not be scientific. It may be a hairdresser coming in and saying, "Oh yeah, that's that fake hair I sold her," or anything like that. And as long they have to be speaking from a specified field of work where they have a specific and I guess what I call it, a requisite level of knowledge in what they're talking about. So that's all that is required. So that's essentially what the Daubert v. Merrill Pharmaceuticals case talks about. So in the process, and the reason we talk about this is some of you guys are going to be in the forensics field, right? So in that field, you're going to be asked to testify about specific things. Um, Sorry, the field of forensics is not just about DNA evidence. Sometimes, there are many forensic forms of identification, fingerprint identification. So you have to be trained and certified on that to be able to come into court and say, well, based upon the fingerprints we pulled at the scene and the test we ran on the fingerprints, it was this person because it matches this many points or whatever. Um, so that becomes scientific evidence. So before scientific evidence can come into a trial, the person is testifying to the scientific evidence, whether it's documents or whether it's just their testimony and opinion. Um, they have to be essentially the foundation has to be laid, and they have to be tendered as an expert. And that's different from what we call lay opinion, a lay witness's opinion. A lay witness's opinion is a lay witness's opinion is an opinion from a person who doesn't have a specified, I guess, certification in a certain field, but they're just a regular person that saw something, and based upon what they saw, they can give their opinion on what they saw. So it's almost like if you can't ask a person, well, how did Boyce feel? Another person can't testify about how I felt, but they can if they say, well, how was Boyce acting that day? Well, he seemed to be crying. He was crying. Now, based upon him crying, what is your opinion of how he? What is your opinion of how he felt that day? Well, he looked sad. So essentially, that's me giving not an expert opinion, but a lay opinion. We'll call it lay because it's just a regular person, not an expert. a regular person giving an opinion on what they perceive, and that's different than an expert coming in and saying why this bullet is the bullet to kill someone, why this shell casing matches this gun. That's not lay opinion. That is what we call scientific or expert opinion, where someone's coming in with a that has to have a specialized field of knowledge to come in and even be qualified to testify. So with when a person is giving us scientific testimony or expert testimony, they first have to be tendered as an expert, or before they're tendered as an expert, the foundation has to be laid for why they're an expert, and you have to essentially ask questions and get and elicit testimony that allows this person to tell the court why we should even be listening to them about this specific situation. So, if a person is um, a ballistics expert that studies shell casings and matching shell casings to guns. They're not just going to be able to get up there and say, "Yep, that was a gun because this and that." No, before they're able to uh, talk about the results of their studies and their opinion, their expert opinion, we have to you have to tell the court why they're an expert. Where'd you go to school? How many hours of studying? What certifies you. In other words, you have to let the court know why this person is who that person is. Now, normally it's the job of the opposing counsel to object when you haven't laid a proper enough foundation. So if of course, if the opposing party is not good enough as a litigant to object when you bring someone in to testify to something that is scientific or expert, an expert situation, and they don't object, of course, the court may let it in just because this person didn't, the opposing litigant didn't object. But for the most part, an opposing litigant is going to object, and they're going to, at some point, they're going to demand that you actually qualify this person as an expert. Like, why should we listen to them? What are their credentials? So of course you have to almost credential a person or bolster them and say, well, this is why this person is certified to talk to this person. This is why this person is trustworthy. And as a jury or juror or trier of fact, you should listen to what they're saying because they went to A&T and got a degree in this, and then they went and got a doctorate, and they've done 500 hours of field work and research in this field, and they wrote a book and or whatever. So all that stuff lets us know, why they are an expert. Now, in doing that, once that foundation is laid, the opposing party can do what we call it's called a witness voir dire. That's different than the jury voir dire. I know you've heard of the jury selection where voir dire just means to speak the truth. So essentially, it's a interrogation of a person while they're on the stand. So we do it in jury selection because we're essentially interrogating or asking questions to figure out who the jurors are, so we can select the jurors. Um, and a witness voir dire, that's when an opposing counsel is now questioning someone that the opposing side is calling and trying to tender as an expert. So outside the presence of the jury, now the opposing counsel gets to question that person and dig into them about why they are or are not an expert, and they get to then, of course, if they feel like this person hasn't really been, the foundation hasn't been laid, and they essentially kind of, like, I guess, quasi cross examine them, they can make the motion that this person not be allowed to testify as an expert. And at that point, the judge is going to now, at that point, decide whether their testimony gets in or not. Um, so the voir dires of witnesses generally do not happen in front of a jury, because the voir dire of a witness is about challenging whether or not this person is going to be qualified to even be allowed to testify or testify any further in front of a jury. So normally the jury goes out, and then you can voir dire that person. Um, Also, when a person is tendered as an expert, even if the court does allow them to testify as an expert, at the end of it all, there's still cross examination where the opposing party can still question them and challenge their validity. Talk about how many cases they've other cases they testified in, and the fact that in all the cases they testify in, they always side with the prosecution. So that seems a little bit biased, as if they're because they're paid to be there. You can even ask questions about how much, the fact that they are paid to be there, because some will presume that if I'm paid to be here, that means I'm also paid uh, to make sure that the result of my test comes out a certain way. So if I'm paid to come in here and testify, that means I'm essentially going to make sure it helps them out. So that goes to bias. So you can also, if a person has a lack of knowledge about certain stuff in the field, it's almost like what they call it, the spaghetti defense that we talked about. Um, Essentially, what happens is a jury can be misled uh, if the opposing party can show that the expert witness didn't know one thing or something, and we can now harp on, well, why should you listen to anything this person's saying? This person doesn't even know about the leading journal in this specified field. They never read it. What type of, how's this person going to be a certified auto mechanic, but he's never read this journal or this important book on being an auto mechanic. So then at that point, it's almost like you're trying to disqualify whatever this person says by pointing out one small thing that they didn't know, or to kind of weaken what they're going to say. So all that happens in the process of tendering an expert. So of course, once that foundation is laid, then the person would be tendered as an expert, and at that point, the judge would decide whether or not to accept them and accept their testimony. So that's just the process. So um, that article, I think I did put the article up. I think I put the article up, where I put Rule 702 of the Federal Rules of Evidence in the Daubert case, and that's just the rules that govern expert testimony, or I use expert and scientific kind of interchangeably, but it's just the process of allowing specialists or experts to come in and testify. How's that process look, and what are the rules? What is the case law that governs it? So that's what we were supposed to talk about last week. So I needed to make sure you guys. I know last week everyone didn't see it because it's kind of weirdly weird. It was in a weird position on the page on the learning module or learning units. So tonight we're going to talk about just the cumulative course review and the final exam review. Of course, we went through the textbook. Textbook's only 135 pages, 13 chapters. We breezed through it essentially. Well, we were on time. So everything went exactly by the syllabus. We didn't get thrown off at all. Chapter 1 just talked about the anatomy of a trial, how a trial goes, the process from beginning to end. Chapter 2, it opened up, just talked about the duties of a prosecution witness. And then chapter 3, 4, and 5, we talked about what to do before court, how to prepare and make yourself the best witness. Then chapter 4 was about persuasion, the fact that you are used as a witness to tell a story, not so it's the attorney's job to now persuade, but how good of a story you tell, how good your story is. Now story kind of implies that it's not true, but let's say how good your testimony is and what you're coming to tell, how convincing it is, will help the attorney when it's time to be persuasive. So of course, I think I told you guys that it's like building a layer cake, right? And I had to tell a client today, we were talking, or yesterday in an interview, we're talking about the probability of going to trial in their case. And I had to tell my client, like, hey, my number one job is to make sure that you are able to tell your story. As an attorney, I don't tell the story. You as the witnesses tell the story. It's my job at the end to bundle it all up in a package that is, I guess, palatable or able to be swallowed or ingested by the jury, and then persuade them to see the story the way you told it. Persuade them to believe whatever your defense is or your theory of the case is. But I can't do that without the story being told. So my first job as an attorney is to try to make sure that they're able to tell their story without being caught up in any what I call evidentiary pitfalls. You know, if you're objected to, how can we win these objections and get these objections overruled? And then, you know, of course, the opposing party, when they're calling witnesses, how can I object to try to keep a lot of it, you know, what we believe to be inadmissible testimony and inadmissible documents or whatever out, so you know, both sides are working to keep certain things out. That's what happens. We're trying to both tell a story and also make sure that the opposing side is telling their story, but doing it by the rules. So making sure nothing inadmissible comes in from their side. And then at that point, at the end, once both stories are told, then it's the litigant's job to now give persuasive arguments in closing. So it's hard to give a persuasive argument if the story that's told from the witnesses isn't a good story, or you know, they get caught up. So you a witnesses a witness's job is not to persuade; they're just there to tell the truth. But how well they tell the truth and how well they testify helps uh, the litigant to persuade at the end. So then we talked about courtroom demeanor and how that's important. That was chapter 5. Chapter 6, we talked about eyewitness testimony and the kind of the ups and downs of that. How sometimes eyewitness testimony is perfect, but it really can't always be trusted because we're humans, and we're imperfect creatures. So sometimes sometimes they say you can't believe your eyes. Sometimes and you definitely can't believe your memory sometimes. So something may have happened a long time ago, and now you're being asked to test. It may be something may have happened 4 or 5 months ago. Now you're asked to come to court and testify about it. And in testifying about it, you may not, you might have forgotten things slipped out. So that's, when we're talking about eyewitness testimony, it's always subject to human frailty. Um, then chapter 7 was just like a parting shot, a few rules for the road. Just kind of wrapping 1 through 6 up, and then we did a quiz. And discussion board 2 was up. Then we moved on to chapter 8, where we talked about precision and simplicity, giving precise, detailed testimony, but however, doing that in a means that can be understood. In other words, you do it. I mean, you give precise testimony, but you use simplistic language so the jury, regular people, can understand what you're talking about. Talked about language, jargon, tone, pronunciation, and volume. All those things are the kind of give me's. Of course, you need to speak where you can be spoken to. Speak slow enough that you can be understood. All that. Chapter 10, we talked about word and phrase pitfalls, things not to say, like to tell the truth and then start talking. What that means is that everything you said before might not have been the truth. So just little things like that. A lot of umming, and I know I a lot. And usually when people use that means they don't have a prepared statement. That means they're talking off the cuff and they're kind of thinking as they talk. So when people that is thinking time. So it lets you know they obviously didn't plan what they were saying. They're going to say. Um, I just did it. So I'm coming off the cuff. I'm going to be going through a list and kind of coming off the cuff. So chapter 11, main objectives of cross-examination, because that's one thing. You're going to be brought to court, and there's going to be an attorney that calls you as a witness, and you're going to testify for that person that you have a rapport with and you're familiar with. But guess what? The opposing side, they have a Sixth Amendment right to cross-examine you. That means you might be asked some tough questions. You might be asked about inconsistencies. You might be asked about whether or not you were in a position to perceive what happened. Where you moving? All this stuff, you're going to be challenged in cross-examination. And the cross-examination challenge may not always come in a mean way. Sometimes the person cross-examining you can be friendly as all outdoors. I know that tends to be my policy. When I'm cross-examining an opposing witness, I try not to be a jerk to them. As a matter of fact, I try to sometimes be nicer to them than I am to my own client, because I want to get a rhythm where they're eating out of the palm of my hand and I'm getting what I want from them. Chapter 12, we talked about recognizing cross-examination objectives, and we talked about those theories of the case, those case theories, those things that the plan, what would you call it? the story we're trying to tell. That is essentially the theory, and you know, of course, you're using the witnesses to get that theory out and bring it to life and make sure it's understood by the jury. Then we talked about chapter 13. That was the end of the book. Tips for testifying on cross examination. So once we moved from the book, we moved. We had a couple cases where we talked about uh, uh, constitutional requirement of cross examination, confrontation and cross examination. We talked about the hearsay rule. So we talked about the Melendez Diaz case out of Massachusetts that went to the Supreme Court. We talked about the hearsay rule and Crawford v. Washington. Talked about those cases. Of course, I posted the cases for your reading, and it wasn't the exact case. It was like the Wikipedia kind of short form of the case to let you know what happened. And then, of course, I gave lectures. So, you know, I gave lectures for everything we're talking about today. Then what we talked about tonight, we talked about admitting scientific evidence, and I put up the Daubert case, so you could talk. So we could talk about the Daubert case and the process for admitting expert testimony or scientific testimony. So that pretty much is what we talked about all semester. Now for the final exam review. The final exam. Okay, the final exam is worth 40 points of your grade, so it is exactly 40 questions. Um, and it is cumulative. That means you're going to have questions that span from everything we talked about, chapter one, all the way through what we talked about the last couple of lectures. So it is cumulative. So you need to be prepared to know to be prepared to answer questions from chapter one all the way through the end of the semester. So it's 40 questions. We're gonna do a little bit of play a little math game with you. We had three quizzes, right? Someone answer me. Did we have three quizzes?
Yes.
Okay. How many questions were on each of those quizzes?
10.
10. So if I was to add the all, if the questions had, if I added each quiz together, that would be 30 questions. So that means it's a possibility that those 30 questions might be used again. That might be exactly what your final is. And Willie Lennon he's celebrating over here. So it might just be questions you've seen before. Strong mic. And so really what you may have to worry about is 10 new questions, and that would make it completely cumulative. So we got questions that cover the entire semester and these new questions. Now, the only thing about these new questions is remember, we've been out of the book. We've been out of the book since chapter 13, right? So we haven't. A matter of fact, you took your last quiz when we got done with the book. So really, the last 10 questions, is, you know, I know it was easy to fall off, you know, because everything was outside the book, right? We talked about, you know, I posted the cases. What that means is there's no um, these last 10 questions aren't really on. You can't look in the book to find the questions, to find the exact questions. So you have to kind of know what you're talking about. Now, are they super hard questions? No, they're not. Um, I would say they're easy. Just test your knowledge. Um, you know, just be worried about what we've talked about over these last few weeks since you took the last quiz. So that means it's a high likelihood that the first 30 first 30 questions of this quiz are all the quizzes, all the prior quizzes. Quiz one, quiz two, quiz three. Then I added 10 questions, and that is the 40-point final. And there's an additional extra credit question that can give you an additional 5 points. So that is the makeup of the exam. So all I'll tell you to do is just to prepare. At least, you know, like, you know, it's a possibility. I can't, you know, I'm not being Mr. Easy Professor, but it's a possibility that, you know, you've been given at least 75% of your final. So really all you got to worry about is that last quarter. Because all, you know, the first 75%, those are recycled questions from the textbook. Possibly. Wink, wink. So just go in and take that. Of course, the quiz will, I mean, I'd say the quiz. The final will be up. It'll be up tomorrow morning. With let me see. What's the day? Yeah, it'll be up tomorrow morning at 8 a.m. Let me double check. Make sure. All right. Let's see now. Yeah, it'll be up tomorrow morning at 7 a.m. So you have from 7 a.m. through next, what's the 24th? The 24th is Wednesday, I believe. Wednesday or Tuesday. Tuesday. So you have from Friday to Tuesday to take the final exam. If you do not take the final exam in that window of time, what's going to happen? You'll have to wait until December to take it, until the actual exam week and on the exam day. The exam day for this class is December 10th. It'll be December 10th, so you'll only have that day to take it, and I'll probably only offer it in the window because the one thing about online class, we really don't have a time, so it'll only be up for that day. Probably 8 a.m. through 11:59 p.m. So that's why you guys. I know you guys know you gotta leave campus for Thanksgiving break for good, right? Um, so if you're leaving campus for the end of the semester, why would you want to have to worry about going home for Thanksgiving and now you're home from Thanksgiving through Christmas? No, you don't come back till late January. Why would you not want to go ahead and kick your vacation off and not have to worry about Boyce's easy final, right? That you got 75% of the questions on already, right? So it would probably be best if you jump in and take it ASAP. Anyone object to that? Can I get an amen from somebody with a microphone?
Amen.
Okay, thank you, Daniel Moore. Um, so I mean, why would you not just go ahead and get it done, right? You don't have to. I can't force you to because the university has an exam schedule. So I know, but I am giving you the opportunity to go ahead and get it done early. So there's one less thing you got to worry about over your break. So you can get that started and start having fun with family and friends and have fun not catching this COVID, not getting that wrong. Um, I think that would be a good situation. So it's up tomorrow at 8. Of course, there are only 5 people. Well, there were 6 on the call tonight. 6 out of a whole class of how many people I got in the class? I got 37 people. So some people just started their break already. So if you know people in this class, you know your friends in this class, let them know. Boys did post the finals going to be up in the morning, so you might want to go ahead and take that between now and next Tuesday, the 24th at 11:59 p.m. If you don't take it during that period of time, you're gonna have to wait till December. So you might want to go ahead and get on there tomorrow and take the exam. You already know it's easy. I'm trying not to say the word easy, but you know it's easy, right? Just go in there and get it knocked out. I'm not trying to beat y'all up in this. This is a 200 level class. This isn't a class where I'm beating y'all up. That's pretty much it. Daniel Moore, of course, we need to talk about making sure you had the honors thing you needed to do for me. So get that. I think you did send it to me though. Um, did you send it to me? You did send it to me, didn't you?
Yeah, I did.
I'll grade that, but you're good. You done what you need to do, so you're straight. Everyone else, everyone, just remember, before we get off this, first, are there any questions? Oh, I do criminal, Tyler, I do criminal defense and traffic primarily, and she asked me what kind of attorney I am. I do criminal defense and traffic defense. I also do like small business stuff, helping people start LLCs and nonprofits. I also do a little bit of estates work. I might draft a will here and there, little odd job things that don't require a whole lot of craziness. So that's what I do pretty much. I pay the bills. Okay, I got you. All right. So if there are no questions, let me give y'all a parting shot. Cause I love you. Now, and I know several of you guys have already seen me a couple times this week. Dan, you got me for another class, right?
I do.
You've heard this already, but this ain't gonna change the way we're doing class right now. Um, in the future is not going to change, at least in the near future. Next semester, a lot of your classes, because as professors, we're not trying to come on campus and get that Rona. Um, so a lot of professors, now I didn't even ask to get online classes. I just got lucky and they gave me all online. I was cool. I said, I'll come on campus if I need to. Cause I didn't want not coming on campus to keep me from getting classes. Each class makes me money. So I was like, hey, wherever you need me, I'm gonna be there. Just pay me. But so I was cool, but I got lucky and all my classes happened to be online. Now it is weird, however, because guess what? I'm used to teaching you guys in person. So I'm used to that energy. And I'm used to it's easier for me to stay on top of you guys and know what you are doing and know when you're unresponsive and haven't been around. I can tell that in class because in class we're physically there, and I can tell that this person hadn't been around in a while. But of course, with just meeting on Zooms, of course, I can tell people on Zooms because I don't think I have anyone in any class has been to every Zoom, right? But because you're not physically there, it's hard for me to see and really question you about, hey, you're doing all right. So if I'm there in person, I can say, wow, this person hasn't been here in a while. I wonder what's up with them. I'll shoot you an email, but it's harder to stay on top of you and bug the crap out of you like us professors do, and showing concern. So what that means in a nutshell is we're not on top of you like we would normally be as professors, right? So that means a lot of what you've been asked to do, you've been asked to remember it, and you haven't had any hand holding this entire semester. And it's gonna be like that at least for the near future. So you guys have to get accustomed to learning in the virtual world. This is what it is now. Um, this is kind of a starter semester. This is the first full fall semester where we've taught, primarily online classes. So of course they've always been online classes, but a small percentage of the classes offered on campus or online, here and there. So we had the last part of last semester where we had to transition into online teaching. But and that was weird because we had in the middle of a semester that you've already prepared for to teach in person. Now you have to adjust and now make it an online class with like a month or so left, with a month and some change left in school. So that was hard. But this is a challenge because this is the first semester where literally a lot of teachers were only teaching virtual classes. So it's not just an adjustment for you. I want you to know that it's also an adjustment for us, because I don't know how other teachers feel, but I like it being in front of you guys better because I feed off of your energy. You guys are young people. I'm older. The energy you guys have is contagious. But sad to say, so is Corona. So I don't want to catch your energy or the Rona. We've had to do it the way we're doing it, virtual. So it's harder to gauge how you guys are feeling, how to who's sleepy, who got their head down in class, who needs to perk up, who I need to ask questions to make sure they got it. It's just different. So you guys in future semesters, now that you've gotten through a whole semester that was virtual and you survived it, I just want you guys to really, really stay on top of it when you come. For those that are coming back, I know some people may be graduating, but for those that are coming back next semester, I want you to be prepared to tighten up, because professors are going to be less likely to even listen to your excuses next semester. Um, so just remember that. Remember, print out your syllabi. Syllabi is, of course, plural for syllabus. Print out your syllabi. Print it out. I know we don't like killing trees. We want to be environmental, but this isn't a normal time where you're in class and I can bug you at once a week or whenever I see you. You guys don't physically get to see me at all, other than this, the Zooms, right? This is the only real time instruction we have. So that means you need to have something in your hand that can help you stay on top of things so you can check it off. I made the syllabus, right? I planned out everything. Guess what? I use it every week to know what I'm teaching and I check it off. If I'm the one that created the instruction and I got it and I printed out a syllabus and I'm checking it off, who are you? You're the student. You didn't plan anything. So it's better for you to have it so you know what we're talking about. You'll know what's due because there's nothing we did this semester that wasn't in the syllabus and wasn't done by plan. So it is what it is. So I want you guys to make sure next semester you tighten it up because I don't know if you guys have classes with me. Anybody got class with me next semester? I guess not. But if you do, I'm not going to be as cool as I was this semester. So I'm not going to be out here reopening uh, um, discussion boards. I'm not going to be extending deadlines. You take that L, you got to eat it. Because guess what? I got deadlines too. This is weird for me. So I don't want you guys to have the attitude that, oh, this whole virtual thing is not working for me. No, it's not working for everybody. We're all in this, including professors. So you just have to deal with what, the cards you were dealt. Play the cards you're dealt, the hand you're dealt. So that's just my parting shot. Make sure y'all prepare for next semester. Y'all get a nice long break. Get yourself right mentally in this Rona world, and come back and be tight. Because I know there are students that, and even in this class, that I've taught before. I recognize names. I'm like, oh, I taught that student before. And some students, I'm like, oh, they're not. That student's not, acting like they used to act. They're not as attentive. They're not on it. And I know a lot of that's because of this stress and the stuff going on with the Rona. But y'all got to tighten it up. Y'all still in this college. You in somebody's seat. There's somebody back home, wherever you're from, that would love to be sitting here and it would love to come here and outperform you. So you got to essentially run from that invisible person. You got to act like you got a person on your neck all the time. Like I got to do better. I got to be working because that person would be. So that's just how I want you guys to attack. And Kyla said, "What am I teaching? I'm teaching the same 4 classes. I got criminal law, which is CRJS. That's 313, 312. Criminal procedures 313. I'm teaching this class, which is 260 again, but y'all ain't taking this because y'all took it. And then I'm also teaching 220 courts and the judicial process, Kyla. So that's what I'm teaching. But that's all I got to say to you. Also, I know you guys by now have heard the news about Dr. Johnson, our interim chair of the department. He was an awesome man, awesome attorney. Actually, before coming to A&T, he was the first. Well, Elon Law was relatively new, but he was the first black dean of that school, of the School of Law at Elon Law. And he carried that. He was in that position for, I want to say, a good 5 or 6 years, and held it down. The school had a lot of growth, a lot of good programs. And then he retired from that, and then decided, we had a vacancy in the chair of our department, and his good friend Chancellor Martin called him and said, "Hey, can you do me this favor?" And he said yes, and he came over here and he served with class and dignity, and held the department together. It's been a pleasure to be under his leadership. He passed away. Dr. Johnson passed away this weekend. So, I don't know how many of you guys had, personal relationships with him or had the opportunity to meet him, but he was an awesome guy, full of knowledge, and it was a pleasure to work for him. So I want you guys to definitely keep the faculty in your prayers because he touched all of us in a different way. He was a special guy. Definitely keep our admin, a faculty admin, Miss Shields King, keep her in your prayers because, of course, she worked with him very closely every day. She was his direct assistant, and everyone else. And we'll make sure we keep you guys in our thoughts and prayers because I know some of you may have had a relationship with them. But definitely, it is what it is. You know, it happens, and it's unfortunate. But I'm glad to gotten to know him and gotten to learn from him in the time that I knew him. So he's a special guy. So that's all I have to say. You guys be good. It was a pleasure teaching you guys this semester. So take care, okay? Aggie Pride.
Thank you.
Thank you, Dr. Boyce.
Good night.
Thank you.